This is the Chapter 3 PowerPoint presentation for Criminal Law CRJ 113. Chapter 3 is classification of crimes and basic elements of criminal responsibility. There's some very important material in this chapter and in this PowerPoint presentation. It's not a very long presentation, but there is some very important material that you need to understand and grasp a hold of. But first things first, we have different types of wrongs in our society. Only two of them are litigated in court. We have crimes, and then we have civil wrongs. But then we also must consider what we call moral wrongs. And that's conduct that is neither a crime or a civil wrong, but is morally reprehensible, such as lying, not lying on the oath, that's a crime, but just lying to a friend, cheating on your boyfriend or girlfriend. Those are morally wrong acts, but they are not civil wrongs. You can't sue somebody for that. And they are certainly not crimes. This is a criminal law class, so we will focus on crime. We will briefly go over civil and torts, but we won't spend a lot of time on it. Crime is defined as the intentional act or omission, we'll get into that in a little bit, that is forbidden by law, committed without defense or excuse, and is penalized by the state. That is our official definition of crime for this class, and that is definition you need to know for testing purposes. Who is the victim of a crime? It may sound like an easy question to answer. This gentleman that is getting punched in the face, is he the victim of this crime? And the answer to that is no, he is not the victim of the crime. For every crime, the victim is society. Now, this person being punched in the nose will be referred to as the victim throughout all the criminal proceedings. However, technically and in reality, the victim of a crime is society itself. Every crime is a wrong against society and not the individual, no matter how personal the crime is. So it's pretty personal if you're receiving a punch in the nose, and you may think that that person's the victim, but society is the victim. And a crime even more personal, maybe a sexual assault crime. As personal as that is, and that can't really be any more personal, the true victim in that crime is society. So crime, the victim is society. And we will see how that differs with tort law or civil wrong. On the crime side of it, we have punishment. We have punishment for crime. And the punishment for crime comes in different forms. It could be a fine. It could be jail time. It could be both. Or it could be death, depending on the offense. And that is how we punish for crime in this country. One of these three ways, or sometimes it's a fine and jail. On the civil side of it, the civil wrong is what we call tort law. And if somebody commits a wrongful act against somebody that results in an injury to the person, or if it's a breach of contract, that's what we call a tort. T-O-R-T. That act, that wrongful act, is called a tort. It's not called a crime. In the criminal law, we have crimes, and under civil wrongs, we have torts. Now, the victim, unlike criminal law, the victim in tort law is the person, not society. So getting back to that man that was punched in the face, if he brought suit against that person that punched him, the person that was punched is the victim. It's not society. It's individual against individual, and the government does not get involved in it. Unlike criminal law, you cannot go to jail for civil or tort law. You cannot go to jail for that. The punishment cannot be a fine, cannot be jail, and certainly cannot be death. The punishment is designed to make the victim whole again. That person that was punched in the face, if there are medical bills, if he lost work, any monetary loss that the victim suffered as a result of that tort, they can recoup that by suing that person in civil court. Although it's a monetary gain, it's not called a fine. So although it may, because money is involved, you may think it's a fine, it's not a fine. It's money that goes to the person that is suing, the victim. And that person is called the plaintiff. When you bring suit against somebody, you are called the plaintiff. And a question that always comes about is, can a single act be both criminal and civil? So for an example, well, the answer to that simply is yes. So that punch in the face, not only did that person commit a crime of battery, but they also committed a tort by punching that person. So that same exact act can be both criminal and civil. Now, O.J. Simpson, for those of you that remember or learned it through history, O.J. Simpson is this gentleman in the brown suit. He was arrested and charged with the brutal murder of his wife and her male acquaintance. He stabbed them to death quite brutally. And O.J. Simpson was a very famous person. He was a former NFL football star and then later turned to acting. And he was incredibly famous, well-known, one of the more well-known celebrities in the world. So this was big news when this happened. And his criminal trial back in 1995, I believe, was one of the first televised national trials. And it was on TV every day. And it went on for months and months and months. And he was ultimately found not guilty of the crime of murdering Nicole Brown Simpson and her male companion, Ron Goldman. And the evidence really was overwhelming. And we're certainly not going to get into why he was found not guilty. That's really irrelevant. The point that I want to make is that he was found not guilty in the criminal court. And then the families of Nicole Brown Simpson and Ron Goldman sued O.J. Simpson for that same act, for murdering those two people. They sued them. And the question came about was, well, wait a minute. He was found not guilty at the criminal trial. Doesn't that mean that he can't be tried again under double jeopardy? Doesn't double jeopardy protect us? And the answer to that is no. Double jeopardy did not apply because not only in that case, but when it comes to criminal law and civil law, double jeopardy does not apply, meaning you can bring both actions can happen. You can be somebody can be charged with the crime, and they can also be sued in civil court for that same exact act, and that is not double jeopardy, because in order for double jeopardy to apply, it must be the same sovereign, must be the same government that's bringing that act. So O.J. Simpson found not guilty for murdering, for the crime of murder. The state of California could not turn around and try him again if they found new evidence, because that would be the same sovereign. But the families of Nicole Brown Simpson and Ron Goldman, they are a different sovereign. They're not even a sovereign than California. So double jeopardy did not apply. And Nicole Brown Simpson's family, Ron Goldman's family, won in civil court. They won, I forget how much the damages were, in the millions of dollars. They were awarded millions of dollars in the civil case. So how can somebody be found not guilty in criminal court, but then be found liable in civil court? And the reason is because in criminal court, the standard of proof is very high. It's beyond a reasonable doubt. And the standard in civil court is a low standard of preponderance of the evidence, which really means 51% of the evidence. Whoever has the most evidence wins. So it was a very low standard for their families to overcome in civil court. And that's why they won in civil court, but the state of California lost, because the standard is much higher in criminal cases. So let's get back to criminal law and let's classify our crimes. We have three classifications. The first is a felony. And a felony is the most serious crime that one could commit. Depending on the charge is when the legislators will decide, how do we want to classify it? Do we want to make it a felony, a most serious type of crime? Do we want to make it a misdemeanor, or do we want to make it a petty offense? So felony is the most serious type of crime, and it qualifies as a felony if the punishment is for more than 1 year in prison or death. So that's why felonies are more serious, because they have punishment that is either a year or more or death. And a misdemeanor is an act or a crime that's committed where you can only do up to a year in prison. So if the crime calls for 1 year in a day, it's a felony. If it calls for 1 year or less, then it's a misdemeanor. And then we have petty offenses, which are minor offenses like traffic offenses, where there's no jail time at all. And these are the three major classifications that we have for crimes. And now we get into the heart of what this class is all about. It's about crimes and elements of crimes. And every crime has 5 basic elements. And in addition to those 5 basic elements, certain crimes will also have additional elements. But at the very least, every crime must have these 5 basic elements. All 5 elements must be present for there to be a crime. If one element is missing, then the crime did not happen. And that's what you really need to start focusing on, because when we start getting into crimes, we're going to learn the elements of each crime, And if one element is missing, then that crime did not happen. The first element is what we call the actus reus. We're going to go over these individually. And then we have the second element, and this is for every crime. The second element is the mens rea. Now, the actus reus and the mens rea are what we're going to spend a considerable amount of time on in this class for the semester, because each crime is going to have a different actus reus and a different mens rea. And you need to know what the actus reus is for that crime and what the mens rea is for that crime. But all crimes will have an actus reus. It just may be a different one than another crime. And all crime has mens rea, and the mens rea is different for each crime. There must be a concurrence, meaning that the actus reus and the mens rea happen at the same time. Causation and social harm results as a result of the act. Again, so if one of these five are missing, then no crime has happened. And let's get into now, we're going to go over extensively actus reus and mens rea. Let's start with actus reus. What is it? It's defined as a person must act or fail to act when required. We call that an omission in order for there to be a crime. So actus reus and actus reus is a Latin term. It means to act. So thoughts alone are not sufficient. It's only when somebody acts on those thoughts, it can become a crime. So actus reus is the action that somebody takes for there to be a crime. Or it could be when a person is required to act under the law and they don't act. So the failure to act can also be the actus reus, and we'll go over that. And when we move along in this semester and we go over individual crimes, you're going to have to identify and memorize and know what the actus reus is for every crime that we go over. Whatever the actus reus is, it must be voluntary. So for example, if someone has epilepsy and they suffer from seizures, and during that seizure, the person strikes someone standing nearby, that would not be a battery because the actus reus would be missing. And the reason the actus reus is missing is because this was not a voluntary act. The person was having a seizure and their arms flailing was involuntary as a result of the seizure. So therefore, because it was not voluntary, the actus reus is missing, and the crime of battery would not be present because that element is missing. But you can see where we can change facts very easily to get a different result. So if the person knows that they are subject to seizures, and then they decide to drive, that could be different because now that person, knowing that they very likely will have a seizure, but get behind the wheel anyway, that voluntary act of driving qualifies as the actus reus. And if they have a seizure while they're driving and they strike somebody, even though they didn't mean to strike that person, the fact that they voluntarily got behind the wheel, knowing that they would likely have a seizure, would qualify as the actus reus. So that could be criminal responsibility. But most of the time, when there is some type of medical condition as a result, then it is not a voluntary act. But if the person knows that the medical condition is going to result in some harm and they take action to be the cause of that harm, then it could be voluntary. So the takeaway is that it must be voluntary. And any Seinfeld fans out there, I know it's a dated show at this point, but one of the more funny shows that was on TV. And here's a scene from the show.
Right, that's all out of time. I'm gonna capture this. Come on! You know what? Don't you?
Well, there goes the money for the lipo.
See, the great thing about robbing a fat guy is it's an easy getaway, you know? They can't really chase you.
It's actually doing them a favor. It's less money for them to buy food. What you want? Come on! Come on, come on!
It's a shame. All right, I'll call NBC.
Officer! He's stealing my car! Officer, I was carjacked! I was held up a gunpoint! He took my wallet, everything!
Okay, thanks anyway. They can't get another plane.
What's wrong with the plane we got? They're just checking it out.
No. Not getting on there. Come on, let's get something to eat here in Sticksville.
All right.
Hold it right there.
What? You're under arrest.
Under arrest? What for?
Article 223-7 of the Layton County Penal Code.
What? No, we didn't do anything.
That's exactly right. The law requires you to help or assist anyone in danger as long as it's reasonable to do so. I never heard of that. It's new. It's called the Good Samaritan Law. Let's go.
So what did they do wrong there? Why were they arrested? Well, there was a law that required them to act. And there are times and there are laws that require us to take action. And if the law requires us to take action and we don't take that action, that is the actus reus. If a person is required to act by statute, then the failure or the omission to perform that act is the actus reus. So actus reus can either be the voluntary action or it could be the voluntary failure to act. Either way, either one could be the actus reus. So an example would be what we just saw in that video, these Good Samaritan laws that require you to take action when you see a crime happening. Another one is to report an accident. If you're involved in an accident, the law requires you to report it. Your failure to report it is the actus reus. Tax returns. You must file tax returns, pay taxes. Your failure to do that is the actus reus. And then we have legal duty relationships. And these legal duty relationships are when somebody has a duty to act because of the relationship they have with that person. An example would be lifeguard or doctors. So if you're at the beach swimming or you're at a public pool and there's a lifeguard on duty and you are drowning and that lifeguard does not take action, that lifeguard has a legal duty to act. And his or her failure to act would be the actus reus. Same thing with doctors. So if there's a legal duty relationship that requires a person to act, then that could be the actus reus. Words is actus reus. Words as actus reus can be difficult because it's very limited on what the government can do when restricting us from saying, from free speech. And that's because we have the First Amendment. The First Amendment guarantees us the freedom of speech. But as we've learned, that doesn't mean that that it can never be, that the government can never stop us from saying certain things. That it's just that it's difficult for them to do that because of the First Amendment. No right is absolute. We don't have an absolute right to say anything we want whenever we want. So the government can pass laws to restrict our words, but it's very limited because of the First Amendment that allows for free speech. The words that the government can regulate are threatening words or very offensive words, or words that could cause harm, such as yelling fire in a crowded movie theater. So that's what makes it difficult for us to just criminalize words. We can, but we have to be careful because of the First Amendment. Now let's look at possession as actus reus. There's certain crimes that the actus reus is just being in possession of something. For example, possession of burglary tools. The actus reus is being in possession of it. Same thing with illegal drugs. Being in possession of the illegal drugs is the actus reus. In order to be charged with possession crimes, the person must know that they're in possession of this contraband. If they don't know they're in possession of the contraband, that's different. And that word know, knowingly, is what we're going to get into next, because it's very, very important. We've learned about the actus reus, and now we're going to get into what's called the mens rea. And again, for the rest of the semester, when we start going over crimes, you're going to need to know what the actus reus is for the crime, and also what the mens rea is for the crime. So what is mens rea? It's Latin for guilty mind. It's what the person is thinking when they commit that actus reus. What was that person? What was their intent when they were doing that actus reus? So the actus reus is the act, and the mens rea is why are they doing that act? Did they do it with a guilty mind? And that's why the mens rea and the actus rea must happen at the same time. So it's the intent or the culpability. It's the mental state a person has at the time he performs that actus reus. The intent to commit a crime. And the crimes that we're going to go over for the rest of the semester are going to have different mens rea. Some are going to require that they knew, they had a knowing mental state. They knew what they were doing. Other crimes are going to require a different mens rea, such as maybe a specific intent. Depending on the crime is going to depend on what the mens rea requirement is. And there's two different types of mens rea or intents. The first is the general intent, and that's just the intent to do the act. For example, battery, punching somebody in the nose. The general intent, the mens rea, is a general intent just to punch that person. That's it. The intent to touch the person. That's the mens rea for battery. And we're going to go over battery later on as well. This is just to show you the difference between general intent and specific intent. For battery, it doesn't have to be the intent to harm the person or any other outcome from touching the person. The only intent required is the intent to touch that person, the general intent to touch that person. And we also have specific intent. And specific intent is the general intent to do the act, and you want some outcome from the act. You want a specific result to come about from you doing that act. So example, assault. Now don't confuse assault and battery. They're two different crimes. Assault is the attempt to touch the person. If you touch the person, it's a battery. If you fail to touch the person, but you wanted to, it's qualified as an assault. That's the difference between assault and battery, and we'll learn those later on. But assault is a specific intent crime because you have the intent to touch the person, and with assault, you wanted an additional outcome from touching that person, and that outcome is to harm the person. So somebody swings at somebody, they had the intent to touch that person, but also the intent to harm that person. So specific intent requires an additional mens rea. It's almost like there are going to be crimes we're going to learn that are general intent crimes, and other crimes are going to be specific intent crimes. And one way to think about specific intent crimes is it requires two mens rea. It requires a general intent to do the act, and then it requires an outcome from that act, which is the specific intent. Now let's take this example. Jim hates Kevin. He plans on killing him by shooting him with his bow and arrow. Jim sees Kevin walking down the street. He gets out his bow and arrow, pulls it back, aims it at Kevin, and shoots the arrow directly at Kevin. Luckily for Kevin, there was a strong wind gust, and that wind blew the arrows away from Kevin and hit Derek instead and killed Derek. Is Jim guilty of killing Derek even though he did not intend to kill Derek? His intent was to kill Kevin. He did not want to kill Derek. So now, does he have the right mens rea? Did he want to kill Derek? And if he didn't want to kill Derek, is he now guilty of the crime of killing Derek? And the answer to that is yes. And the reason is the law recognizes what we call transferred intent. And in situations like this, what happens is the intent that Jim had for killing Kevin transfers to Derek. The crime is so bad enough and the action was so dangerous enough, we're going to do what's called transferred intent. And we're going to transfer the intent that Jim had for killing Kevin, and we're going to transfer it now for Jim killing Derek. So even though he really did not intend to kill Derek, we're going to transfer that intent for Kevin onto the intent for Derek. And now Jim would be guilty of killing Derek because the intent transferred. So there is this in our law that's very real and it's used all the time. We take the intent that you had and we transfer it because the act was egregious enough that we don't want it to just go unpunished. And then the other two elements that we're going to look at, we're not going to look at harm to society. I think that's kind of self-explanatory, but the other two elements are causation and concurrence. And causation just means, did the act cause the harm? If the act didn't happen, would the harm have happened? So if Jim did not shoot those arrows, would Derek have been killed? And the answer to that is no. Therefore, causation happened. The act caused the harm of killing Derek. And concurrence is actually very easy. It just means that the actus reus and the mens rea must happen at the same time. When a person does the act, they must do so with the right mens rea that's required for that crime at the same time. You can't do an act and then 5 minutes later attach a mens rea to it if the mens rea didn't happen while the act happened. And that's what concurrence is. So although this was a pretty short presentation, there is some very important material in here. In particular, you need to understand and really grasp the concept of actus reus and mens rea. We're going to spend an awful lot of time this semester talking about the actus reus for crimes and the mens rea for crimes. So if you have any question on this material or any questions at all, please let me know. And we will see you for the next presentation. Thank you.